So our case study is Ravi and Salim met through a dating app and had been regularly meeting for some time. During one of their dates when Salim was slightly inebriated, Ravi forced himself upon Salim. The next day, Salim felt violated and hurt, but was not sure what to do next. Now, this could be a common scenario anywhere, right? And what does a person do after that? So where does the law come in? So sexual offenses in India under the Indian Penal Code operate in the male-female binary. They only recognize the male as the perpetrator and the female as the victim, and don't recognize any other gender combinations. So what Salim would have to do is go under provisions of the IPC such as hurt or grievous hurt, which are neutral provisions on general physical violence, but do not capture this power dynamic or the power dynamic of sexual violence specifically. So he would have to go under a lesser provision as opposed to sexual violence provisions. And how do we think about violence, right? So when we looked at a lot of these criminal laws, we realized that LGBT plus people are excluded at two levels. One is at the level of language, because it says male, female, so it excludes transgender persons who are not part of the law in any case. Also at the level of the assumptions of the law. A lot of these criminal laws are based on heterosexual assumptions. So if you look at the definition of rape, it requires penetration. Even after the Justice Verma Committee changes to the definition of rape, penetration is still necessary for rape to be proven. But in other contexts, rape may happen in, sexual violence may happen in various other ways, which are not part of the law. And this is not restricted to substantive provisions of the IPC, because criminal law operates at the level of procedure. It operates at the level of evidence. And we need to think about the entire criminal law framework when we think about querying laws relating to violence. Because for instance, even if you are a victim of rape, you go to the police station. Currently, a female police officer has to record your statement. What happens if a gay man goes to a police station? How do you even account for that kind of power dynamic? Who will take the statement? Similarly, under evidence laws, we have a presumption where if a woman says that there is lack of consent, it's presumed there's lack of consent. How do we even translate these presumptions into an LGBT context where power would operate very differently? How would we even, so when we started this process, we started changing these pronouns in these laws. And we realized that's not the answer, because you can't merely change pronouns and come up with an inclusive law. You need to change the assumptions in the way it's drafted to actually queer it. Thirdly, there are contextual provisions. So in India, a lot of the criminal law reform that has happened is due to efforts of the women's movement. And legislation such as the Protection of Violence, Domestic Violence Act is a very good example that accounts for the lived experiences of women in a family setting. Even the remedies that it gives, such as residence orders, maintenance, etc., are contextual to a domestic family. Now, how do you translate something like that to an LGBT context, which might be very different from a heteronormative context of a man-woman family? Another key issue in terms of debates in existing literature was victim neutrality. Now, this has been debated since the 1990s, where the 172nd Law Commission spoke about how we need to come up with a victim-neutral rape law in terms of making it both perpetrator-neutral and victim-neutral. But at that point, the women's movement sort of criticized this recommendation and saying that you can't just change rape provisions overnight. They represent a certain power dynamic. They represent a certain condemnation to an act and recognize a certain social reality. So you can't be unmindful of it and just do away with rape and introduce a completely neutral provision. The debates also happened when the Justice Verma Committee report came out, which is after Nirbhaya's rape case, where Justice Verma Committee recommended a victim-neutral rape law and an offensive sexual assault to include non-penetrative acts. And this is something that has been happening for some time now in terms of how do we think about neutrality. Do we make it victim-neutral? Do we come up with new offenses? Do we retain the offense of rape? Do we come up with new sexual offenses for LGBT people? So how do we think about some of these things?
And or how do we use existing provisions in the law, if at all? So and here perhaps it's important to consider two questions, similar to what we were discussing when we encountered identity. One, does the law recognize the special kind of violence that is perpetrated against LGBT plus persons? And if yes, does it have effective remedies for it?
Yeah.
And this might require us to take a step back and ask why it's important again for the law to recognize and to address or redress different forms and expressions of violence. So, as Akshat mentioned, in a broad and perhaps crude sense, all forms of violence constitute some form of hurt or grievous hurt under the Indian Penal Code. But despite that, the code has specific provisions for sexual violence, and the Reason for that is the law is going beyond the mere provision of a remedy. It's calling out a specific kind of violence that it finds particularly abhorrent and is expressly condemning it. Now, this is the way in which the law responds to different kinds of oppressive and predatory behavior in society. This is why we have a special law to address atrocities against members of the scheduled castes and scheduled tribes, or it is why we might have debates about whether we need to introduce a separate provision in our criminal procedure, in our criminal laws for lynching. So these are, as in the expressive function of the law is something to take into account of when considering how to queer it in the context of violence.
And also articulating a theory of power. So in order for law to perform this expressive function, the law needs to understand how power operates. And before we even think about law reform, maybe we need to ask ourselves this question in terms of how power operates and theorize how power would work in LGBT relationships. Because often violence is not just against LGBT people, it may also be within the community. So how do we account for these power differentials in terms of thinking about law reform?
Yeah, and also as we discussed very usefully and people brought up today in the consultation, that it's impossible to think about queering the law in the context of violence and making it work for LGBT plus persons, one, without actually doing a proper empirical research on the different kinds of violence encountered, or and I know that there are already organizations doing that, but perhaps we need to do more of that to be able, or to understand that better before we can recommend a change to the law. And second, again, that this project of queering the law forces us to look at our criminal justice system as a whole, and take a harder look at the justice system, because it's broken for every kind of person, and as a result of that has a disproportionate impact on the LGBT plus community. So it's an exercise that goes to the very heart of our functioning as a rule of law society, and queering the law will not happen unless we look at the criminal justice, fixing this broken criminal justice system holistically. And especially considering the sort of history of persecution and harassment that has been perpetrated on the community by police and state authorities.